Welcome to Talk Law Radio with attorney Todd Marquardt of the Marquardt Law Firm at marquardtlawfirm.com.
Welcome to Talk Law Radio. I'm Todd Marquardt. This is the show where I help you discover your legal issue blind spots by listening to me talk about the law on the radio. Live on the radio on 6:30 a.m., 9:30 a.m., and on Sundays it's 9:30 a.m. I'm always getting that mixed up, but if you found me, you know what station it is. But I'm also on podcasts everywhere, Facebook, YouTube, and talklawradio.com. Now it's time for legal analysis and commentary for Mom and Pop with Talk Law Radio. So what's today's episode about? It's going to be about some significant court cases that have been going on since the last time we talked. And you should listen because there are so many laws and changes in laws. I want you to avoid ignorance of the law because God started with one law. Don't eat from the fruit of that tree. Then we have the 10 Commandments. And now we have municipal, state, and federal laws that just never end. And so these laws, these changes in the laws, they might impact you without you knowing it. So I'm out here trying to find them for you. Today there's 4 hidden legal issue blind spots because there's 4 court cases I want to tell you about. The first one is about whether Texas, the state of Texas, may enforce Senate Bill 4, that's Texas Senate Bill 4, which was incorporated into Texas Penal Code Chapter 51. I'll tell you more about that later. Second court case is whether states like Colorado may remove former President Trump from the primary election ballot under the terms of the Insurrection Clause, which is Section 3 of the 14th Amendment to the United States Constitution. You probably already know the answer to that, but I still want to talk about the case just a little bit because I think it's significant and there are some interesting parts to it. The third one is whether you must report beneficial owner information to the Financial Crimes Enforcement Network, even though a federal district court in Alabama held that the regulation is unconstitutional. And then finally, whether the sentencing of those convicted for activities on January 6th should be reviewed and or reduced. So let's get into it. I was going to tell you about the meaning of Senate Bill 4, which is now Penal Code Chapter 51. That's where the state of Texas wants to prohibit illegal entry into the state of Texas. Of course, we share our border with Mexico, and you've probably heard a lot about that in the news also. Just trying to find the statute here. It's a long statute. Section 51.02 of the Texas Penal Code says a person who is an alien commits an offense if the person enters or attempts to enter this state directly from a foreign nation at any location other than a lawful port of entry. An offense under this section is a Class B misdemeanor, except that the offense is a state jail felony if it is shown on the trial of the offense that the defendant has been previously convicted of an offense under this section. So what that means is first time it's a Class B misdemeanor, second offense is a state jail felony, and the difference between those two is just how long the sentence would be. So that's what the law is, just in shorthand. The law was passed by the Texas Senate and House of Representatives and signed by Governor Abbott. This complaint, the lawsuit was filed December 19th, 2023. And what's interesting about this whole situation is that the speed in which this law went through the court system. So that's why I'm telling you what the dates are. So filed back in December, but then the court finally got around to deciding something on it, and that was it decided to issue a temporary injunction on February 29th, 2024. What that means is the court says that the state of Texas cannot enforce this law as of February 29th. Well, the state of Texas appealed to the Federal Circuit Court, and the appellate court issued a stay, which means that the temporary injunction was not enforced, and which means that the state of Texas would be able to enforce Chapter 51 of the Texas Penal Code. Well, then it was appealed to the United States Supreme Court, and the United States Supreme Court didn't decide whether this was a good law or not, but the United States Supreme Court lifted the stay that the Circuit Court of Appeals had rendered, which means that the temporary injunction is in force, which means that Senate Bill 4, Chapter 51 of the Texas Penal Code, cannot be enforced by the state of Texas, pending the resolution of this case. So the Justice Department, their argument can be summarized by a press release that they put out. It says, to challenge Senate Bill 4 under the United States Constitution's Supremacy Clause and Foreign Commerce Clause. The Constitution assigns the federal government the authority to regulate immigration and manage our international borders. Pursuant to this authority, Congress has established a comprehensive framework governing the entry of non-citizens into the United States and the removal of non-citizens from the country. Because Senate Bill 4 is preempted by federal law and violates the U.S. Constitution, the Justice Department seeks a declaration that Senate Bill 4 is invalid and an order preliminarily and permanently enjoining the state from enforcing the law. Enjoining means injunction, which means to stop something. So that's the Justice Department's argument, and that's what that court case is all about, is whether the state of Texas can prosecute those who illegally enter the state of Texas. And the reason I think it's important for you and me is because there's all these people coming into the state of Texas, and we have to support them with our tax dollars, or we have to risk our lives or risk our property, if there's crimes that are going to be committed by known terrorists, or if they're going to be committed by people that committed crimes in other countries that are coming here. So that's why I wanted to talk about it. But I did talk about this a few weeks ago with El Conservador, George Rodriguez, but I didn't get to talk too much about the text Todd line, and these are people in my inner circle that let me know how they feel about the topics that I discuss. If you want to be part of my inner circle, you can text me at 210-538-4770. Text Todd at 210-538-4770. And once you're on my list, I will reach out to you periodically and ask you how you feel about certain things. And you don't have to agree with me. It's not going to hurt my feelings. Please don't say nasty things. I think we can be civil. So anyway, one comment was that if there's this law, Senate Bill 4, Chapter 51 of the Penal Code, is enforced, then immigrants will feel unsafe to report crimes against themselves, and that would allow criminals to thrive in silence. And nobody wants that, but it's really created by the open border if we were to close the border, then these criminals would not come into our territory. Somebody else told me that I believe in states' rights. I also believe in the right to protect your property from trespassing. So this person probably supports the effort to put concertina wire, which is the razor wire, all over the border. And I read a news report recently that Governor Abbott had allocated $130 million for the Texas National Guard to set up a base there. So I just wanted to share those things with you. Let's talk next about Trump versus Anderson, which is the Colorado case where some angry voters sued the Secretary of State of the state of Colorado to demand that former President Trump be removed from the Republican primary ballot. Well, we already know that that was stopped, that President Trump was on the Colorado primary ballot because Colorado is one of the Super Tuesday states. They had their primary election yesterday. President Trump won the primary in that state. But I still wanted you to know what's remarkable about this going all the way to the Supreme Court is that all 9 justices voted to say that the state of Colorado, the Secretary of State, any state court could not remove a candidate, a federal candidate anyway, from the ballot. And I'll go through some of those reasons. The question was, the case raises whether the states, in addition to Congress, may enforce Section 3 of the 14th Amendment. That's the insurrection clause. If you commit insurrection, then you're not eligible to be on the ballot. The United States Supreme Court concluded that states may disqualify persons holding or attempting to hold state office, but states have no power under the Constitution to enforce Section 3 with respect to federal offices, especially the presidency. So that's important that they say that, don't you think? Because you don't want one state that's going to affect the election for the whole nation. And something else that was really interesting about this case, I read the case and had one of my new paralegals, Tyrone, read over the case as well to highlight and find how many references to statutes and cases and other law and supporting references were dated in the 1800s. Can you guess? If you want to take a guess, text Todd at, let me give you the number, 210-538-4770, 210-538-4770, and I'll let you know how close you come. But I counted, and it's just really interesting. This was like a law that came about after the Civil War because the Union did not want those who had rebelled against the government to then serve in the government afterwards. Another relevant statute to this whole issue is a criminal statute, a federal criminal statute that penalizes people that commit insurrection. Former President Trump was never prosecuted for this crime, but here it is. Whoever incites, sets on foot, assists, or engages in any rebellion or insurrection against the authority of the United States or the laws thereof, or gives aid or comfort thereto, shall be fined under this title or imprisoned not more than 10 years or both, and shall be incapable of holding any office under the United States. So if somebody, some prosecutor somewhere, wanted President Trump to be held account for insurrection, this is the statute that they should have prosecuted him under, in my opinion. Okay, let's go to court case number 3, something else that you should be aware of if you know somebody who has a corporation, LLC, limited partnership, or any other type of business entity that's filed with the Secretary of State. There's a new regulation called the Corporate Transparency Act that went into effect on January 1st, 2024, and we've been helping people to report their beneficial owner information to the Financial Crimes Enforcement Network. And there was a lawsuit brought to declare this law and regulation to be unconstitutional. It was brought by National Small Business United, doing business as the National Small Business Association, versus Janet Yellen in her official capacity as Secretary of the Treasury. And this court case was brought in a federal district court in the state of Alabama. That's the United States District Court, Northern District of Alabama, Northeastern Division. And this court found that the law and regulation is unconstitutional. They issued a summary judgment, which means that there's no question of fact, that based on all of the pleadings, they can render a decision just based on the law. And something I found interesting about this case was on the very first page. It says, the late Justice Antonin Scalia once remarked that federal judges should have a rubber stamp that says, stupid but constitutional. The Constitution, in other words, does not allow judges to strike down a law merely because it is burdensome, foolish, or offensive. Yet the inverse is also true. The wisdom of a policy is no guarantee of its constitutionality. Indeed, even if the pursuit of a sensible and praiseworthy end, Congress sometimes enacts smart laws that violate the Constitution. This case, which concerns the constitutionality of the Corporate Transparency Act, illustrates that principle. So the motion for summary judgment was granted. The Corporate Transparency Act is unconstitutional because it cannot be justified as an exercise of Congress's enumerated powers. Remember, our Constitution is unique in the world because it's a Constitution that only gives the government specific powers. All of the powers not given to the government are reserved by us, the people. So this is what makes the United States unique and what makes us such an exceptional country in the world. The Corporate Transparency Act is unconstitutional because it cannot be justified as an exercise of Congress's enumerated powers. This conclusion makes it unnecessary to decide whether the Corporate Transparency Act violates the First, Fourth, and Fifth Amendments. I talked about this a few weeks ago. There were other arguments in the lawsuit to have it declared unconstitutional. One of the powers that the Constitution does give Congress is the power to regulate commerce. We call that the Commerce Clause. This district court, this federal district court in Alabama, found that the Corporate Transparency Act does not regulate commerce. The statute does not include the word commerce, which is what they call a jurisdictional hook, which is a legitimate nexus with interstate commerce. Nexus means a connection. So what the court said is, if Congress wanted us to believe that this Corporate Transparency Act was enacted under the authority of the Commerce Clause, it should have written that into the statute. The absence of a jurisdictional hook, like mentioning the Commerce Clause, is even more mystifying because Congress knows how to include one when it wants to. So commonplace are these jurisdictional phrases that, for purposes of statutory interpretation, courts assume that Congress uses different modifiers to the word commerce in the design and enactment of its statutes. When Congress legislates pursuant to its Commerce Clause authority, the phrase affecting commerce indicates Congress's intent to regulate to the outer limits of its authority under the Commerce Clause, while the general words in commerce and the specific phrase engaged in commerce are understood to have a more limited reach. So that's interesting, isn't it? Let me skip around a little bit. You might also be thinking about the necessary and proper clause. Well, that's used to carry out an enumerated power. It doesn't stand alone. If the power is not enumerated, a necessary and proper clause cannot follow. There is not a logical causal link between the taxing power and the collection of beneficial owner information. So besides the Commerce Clause, the government argued that the Corporate Transparency Act had authority under the taxing power of Congress. And this court did not find that persuasive, and they did not think that it would be necessary and proper anyway, because financial institutions already collect this information in banks and other financial institutions under the 2016 Customer Due Diligence Rule, which requires covered financial institutions to identify and verify beneficial owners of legal entity customers. Okay, one more case. That's U.S. versus Brock. Brock was, let's see, what's his full name? Larry Rendell Brock. He was prosecuted for activities that he engaged in on January 6th at the Capitol of the United States. And this case is all about whether the district court properly sentenced him. Well, not only did they I have to go back, explain something. When federal crimes are committed, the federal law says how long they can go to prison. It's not up to the total discretion of the court. They have guidelines. We call these sentencing guidelines. And that's what this case is all about, is whether the district court that prosecuted this individual and probably lots of others properly applied that. And so there was a 3-level enhancement that, of course, required him to stay in prison for a lot longer than he would have under the statute, the penalty that sentences him for the crime that he committed. And it's all based on substantial interference with the administration of justice. And I'm going to have to talk about this case again next week because I'm running out of time. But I have maybe another minute or two just to remind you to join me on social media. Find me on Facebook, Twitter, or what was formerly known as Twitter, which is now known as X. You can find me there. I have started polling the audience about certain topics. If you'd like to join a poll, please search me on X, formerly known as Twitter, or LinkedIn. I can do polls on LinkedIn as well. You can search Talk Law Radio there. And also find us on Facebook. We have videos on Saturdays for live shows, and on YouTube where we break up the live show into 4 segments so you can watch it in 10-minute increments. Be sure to forward my videos to your friends and ask them to please subscribe to Todd Marquardt's Talk Law Radio because it's so fascinating to learn about the law. It really helped me out. I'm trying to get to 1,000 subscribers on YouTube, and I also just want to hear from you. I want to talk about those laws that you're interested in and are having trouble with. And I've got to wrap up the show. I thank you for listening. I'm Todd Marquardt. I'll talk to you later.
This has been Talk Law Radio with attorney Todd Marquardt, brought to you by the Marquardt Law Firm. You can learn more at marquardtlawfirm.com. And be sure to listen to the full Talk Law Radio show Saturday mornings at 11 on 9:30 a.m. The Answer.
Each week, attorney Todd Marquardt talks about the law. His mission with the Talk Law Radio show and podcast is to help you discover your legal issue blind spots. In the beginning, God had one law. Don't eat from the fruit of that tree. Then came the Ten Commandments. Now we have federal, state, and municipal lawmakers that won't stop creating new laws. Laws that might impact you without you knowing it. Listen to the show and drop a line on Facebook or email host@talklawradio.com and let the host know what you think of the show, the topics you want to hear, and whether you want to be a guest.